Wow. There we go. So I have a PowerPoint, which I understand should be available after the session. I'll confirm that, but we'll figure out how to do that. And if anybody wants it, just let me know, and I'm happy to give it to you. And so I'm going to try anyway to leave some time at the end of the session for any questions that you have. This is an update session, and just as important as me going through some of the legal changes are things that have come up for you, new trends that you see coming up that you'd like to discuss. And so I would very much like to leave some time for that. But we will begin with the update of changes that have happened in the CalWORKs program over the last year. And I'm going to begin with something that actually started 2 years ago, but the implementation of it was happening during the last year. And something very important for all of you, SB 1232, the really important changes in welfare to work to allow access to higher education as a welfare to work activity. And SB 1232 really changed the landscape of what is available for CalWORKs recipients in terms of being able to go to higher education as their welfare to work activity. And it did really 6 major things that I'm going to go through. The first is that if somebody wants higher education to be their welfare to work activity, they are entitled to it, and the county can no longer say no. The county can no longer say, no, I think a better path for self-sufficiency for you is to go work at Walmart. No, if somebody wants to do higher education as their welfare to work activity, they are entitled to it. From previous years, the county, if somebody does not have a high school diploma or the equivalent, the county is always required to offer and allow a GED program or equivalent high school program to get a high school diploma. And so people are still entitled to that. And then assuming they're eligible to enroll in higher education, the county must now always accept higher education as the welfare to work activity. Secondly, is that study time for people who are in higher education is now up to 3 hours for every unit. There was a little bit of an issue that I'm not sure has been entirely resolved about classes that are not done by unit, that they're done by hours. And I'm not entirely sure there was a final resolution of that. But for classes that are done by unit, which is the vast majority of classes, it is 3 hours of study time for every unit. If somebody is full-time enrolled in higher education, that meets their welfare to work participation requirements, end of discussion. No more somebody has to find 2 hours of some other activity because they're only in class for 12 hours and they don't have enough study time. No more. If somebody is considered to be full-time enrolled by the institution, by definition, they are now meeting their welfare to work requirements. And the fourth major thing is no longer can the county require somebody to do job search or job club if they are enrolled in higher education. And so the welfare to work process has been you do the initial orientation and then OCAT. And then after OCAT, you did 4 weeks of job search, whatever the county called that. And the county sort of had the option if they wanted to say if you were in school, they weren't going to make you do it, but it was entirely a county option. No longer, if somebody is enrolled in a higher education program, the county can no longer require job search. And next, the county welfare department can do assessments. They still can do that. They still can do OCAT, and they're supposed to, but that is only to identify barriers that people have to self-sufficiency. That assessment cannot be used to deny higher education, regardless of how it comes out. OCAT might say that higher education is the worst thing in the world for the recipient, and it does not matter. If the recipient wants to go to college, they are entitled to do so. And the only thing that OCAT can be used for, that online computerized assessment tool, the only thing that can be used for is for the county to identify barriers, and then the county to provide barrier removal services for the barriers that are identified. And last but not least is the standard supportive services payment for people who are enrolled in higher education. Instead of people needing to submit, their syllabus with every a book that's required for the class, for all their classes that they're taking, and figure out how much those cost and submit that and hope the county pays supportive services in advance in enough time to be able to actually get the books before somebody is enrolled. No more of that. It is now a flat rate standard payment that every student gets for supportive services. For folks who are in semester systems, it is a $500 payment for full-time and $250 payment for part-time. For folks who are on quarters, $350 for a full-time student and $175 for a part-time student. The county cannot ask for receipts to determine how the money was spent. The county cannot require that money be given back if their actual supportive services costs are less than the standard amount. The county cannot inquire at all about that. They just have to write the check. If somebody has expenses that are higher than the actual amount of supportive services, then people can ask for that higher amount of supportive services, and they would have to provide documentation for that. And the question in the chat is does this include summer classes? It certainly does. Absolutely, it does. And then last, and this has been a bit of a point of contention that we've had with a couple of counties. I see a question: who determines full-time status? It is the college that determines full-time status, not the county. And actually, I didn't put it on this slide, but the college also determines whether somebody is making satisfactory progress in the program, not the county, the college. And so the way that the state policies decided to do it was the simplest way possible, which is if the college lets you enroll, by definition, you are deemed to be making satisfactory progress, because the college would not let you enroll if you were not making satisfactory progress. And I'm seeing some questions in the chat here, so hold on. Let's see. Has there been a discussion versus full-time versus part-time? I mean, and the answer to that is it's all defined by what the university says. What the college or university says is full-time enrollment. And so, and Vicki is absolutely right. CDSS is working on additional guidance for that. I think for the summer term, it's going to be how the college defines full-time enrollment. And so that's going to be different than for the regular term because the classes are so compressed. But it is all entirely how the college defines it. And I see in the chat that someone has been using the catalog, and for some reason there have been issues about that. I mean, if the catalog or the college in some other way defines it as full-time, then it's full-time. And if the county is not accepting that, folks should be requesting hearings to challenge it. That's the way to do it. Sarah, I see your hand. Give me 1 second. I see one other question in the chat. What if they're in only 9 units? And again, it depends how the college defines it. Likely 9 units is defined as part-time. And so that would be the part-time amount. Of course, if actual expenses are higher than the supportive services, flat supportive services amount, people can ask for the actual costs. Sarah, yes.
Yes, hi, I was the one that presented that question. Our college defines, well, we have full-time, three-quarter time, part-time, and less than part-time. So I guess the issue is that we've had students who are taking 11 units during the spring and 1 unit during the intersession semester, which is a brief 3-minute accelerated course. And they're saying that that is a whole entirely different semester, that they're not entitled to full-time payment for ancillary. And so I think we are just having a little bit of pushback with that the college is supposed to define full-time versus part-time. I guess they're just not understanding that a student who is taking 11 units, I mean, that's as full-time as almost you can get, you know, up to 12 units. And so I just want to know if there was any discussion on maybe if full-time can be like 10 and above or something like that, because that's a lot of classes to take. It's just, I don't know if anybody else is having a problem with that, I guess.
Yeah, it's really, I mean, it might be worth having a discussion with DSS about that, but the answer is how the college defines it. So if the college defines taking 11 units and then taking an intercession class as full-time, then it's full-time. And if the county does not accept that, that's when folks need to be requesting hearings and going to hearings and presenting the evidence that the college defines that as full-time.
Great, thank you so much.
And I see, let me take this question in the chat here. Okay, that's not a question, sorry. And I see, would I be willing to post the slides? Yes, I will figure out how to do that, how to get the slides posted. And Aqua Kiva, I'm sorry I destroyed your name. I'm sure I did.
It's okay.
I see you have your hand up. I apologize.
It's okay. It's Akiva. However, I've been told that once the student has exhausted their standard payment and they need additional funds, they must provide receipts on what the standard payment was spent on.
That probably is reasonable because they have to show that their expenses are actually more than the standard payment.
Okay, great, thank you.
And so there's no way to show that the expenses are higher than the standard payment unless you show that you actually spent the money. So that actually makes some sense to me.
Thank you.
And Nadia.
Hi, is there any discussion, and I apologize if you said this and I missed it, about aligning the supportive service amounts with how Pell is paid out full-time, quarter-time, or three-quarter time, half-time, quarter-time, instead of this whole 500 for 12 units and 250 for 11 and under, you know, because that would be way more in line with what the colleges are doing.
Not that I know of. That would take a change in the statute. And that may very well be a discussion worth having. Just what Kevin needs more work, but this was Kevin Aslanian's statute for those of you who know Kevin, and he shepherded this through the legislature along with a few other folks. And it might very well be worth it to talk to Kevin about cleanup legislation. I'm not sure if there's a cleanup bill or not for a few other things. There might be. So it's definitely, I think, worth talking to Kevin about that. If that's how a lot of colleges do it, it may be worth looking at that. And I see Vicki put in the chat the bill number for the cleanup legislation. So maybe if you don't mind, Nadia, I'll bring that up to Kevin, and maybe I'll have Nadia contact you. I'll have Kevin contact you if that's okay.
Yes.
About the issue. One more thing about students before I go on to some other new stuff. AB 1326 last year, I just found out about this. I actually missed it when it was passed. requires the county welfare departments to designate an employee as a staff liaison for academic counselors and other professional staff at publicly funded higher education institutions located within the county, and to provide information and services to students. And the reason I found out about it is because I got an email that CDSS is convening a work group to give recommendations about protocols of engagement. So I am not entirely sure what this is, and I'm not entirely sure that I'm going to be able to do that work group. But I know they're having at least 5 meetings, and I know one thing for sure they're going to talk about is confidentiality protocols and perhaps making things easier to release to community colleges. I'm not sure entirely, but I think this is, stay tuned. There's something coming about this, and there's going to be this work group that I hope at least some community college and other higher education people are involved in. And if not, it's definitely worth asking that some community college people be involved in that. Moving on to a few other things, and I'm happy to come back with more questions about well, let me say one more thing about education, sorry. These 1232 did not do anything to SIPs. And really, at this point, I can't think of a reason why it would be in somebody's interest to be a SIP anymore. And in some ways, it's detrimental because the state has taken the position that SIPs still only get 1 hour of study time per unit instead of 3, because somehow it's some magic different thing that 1232 doesn't apply to at all. So it's actually, if someone's in a SIP, it's actually a little bit disadvantageous for them. The other thing is a SIP would stop at a undergraduate degree. 1232 allows graduate programs as well. And so someone can be in a graduate program, and that counts as well. And that is a good point. Yes, a SIP would be used for private colleges. That's correct. Very good point, Christy. Thank you. Because 1232 is for publicly funded institutions of higher education. And Krista, it's a self-initiated program. What is a SIP? And that is for someone who is enrolled in their higher education program at the time of their assessment for CalWORKs. So they've already applied, they've been granted, and they're at the point of assessment. And it used to be that that was the way to really force the counties to allow somebody to be in higher education. But that's no longer the case. The counties have to accept people and accept higher education as the people's program now. And so that path, the SIP, to force the county to accept it really is not needed anymore. It is still needed if someone is going to a private institution. That is true. Let me go on to a few other things, and I'm happy to come back if people have more questions about the education pieces. And I'm sorry, I see one more question. Carlos asks, is that language available anywhere, SB 1232 not beneficial to SIPs? I mean, the only thing close to that is in both the all county letter and the all county information questions and answers. There's a little bit about SIPs, and both of them say that the study time, the increased study time to 3 hours per unit, doesn't apply to SIPs. So that would be the closest, I think, to saying that. Thank you. Can we encourage our participants to be classified as VOCs? We can, but and that's actually a really good segue to what I am going to talk about right now. The whole vocational college thing was important for the 24-month time clock. And as you'll see in just 1 second, that is no longer relevant in 4 days. So the next major change is the time on aid clock is changing. It is increasing to 60 months time on aid effective May 1st. And that really crazy, confusing 24-month clock is now gone. We cared about vocational education because it could be an extension of the 24-month clock because 1 year of it counted as a federal program. We don't have to worry about that anymore. No more 24-month clock, it's gone. The other important thing about this is it took legislation last year to do this, but now people whose families are still on CalWORKs, for example, they still have children in the household who are receiving CalWORKs, will be automatically added back in to the assistance unit. Initially, the Department of Social Services position was to require people to reapply. And because of legislation that passed last year, that will not be the case at all. People should be allowed, they should be re-added to the household without doing anything, hopefully. I'm seeing lots of messages here. So, okay, they're all very good. Okay. So that's really good news about the time on aid. And actually, we didn't put in here, but I'm sure folks have noticed it that there was another grant increase last year, and hopefully, we'll see what happens this year. But there may very well be more of that coming. We shall see. The next thing is something called CalSAWS, which some of you may be familiar with already if you're in counties that have implemented it. This is the new welfare department computer system that has replaced C4 and Leader in Los Angeles. And along with that is a brand new online portal for clients called Benefits Cal. And this is, you may have worked with C4 yourself or YBN as ways that people could apply for benefits online and do a few things online. Both of those are now no longer, and they have been replaced with a new system called Benefits Cal. That is now operational in all of the former C4 counties. And as of this weekend, it is now operating in Los Angeles as well. There was a long delay in Los Angeles because of a problem with the imaging system, but they have now, it is now online in Los Angeles. And I haven't heard of any major problems yet, but who knows, we shall see. For the CalWIN counties, that is the 18 counties that use the CalWIN computer system, rollout will begin starting in fall of 2022 and will be about a 2-year process. The reason for that is the CalSAWS system, the kernel of the system is the same as C4 and Leader. It is an update to both of those systems. It is a completely different system than CalWIN, and so those counties are really starting from scratch on a brand new system that they have no idea how to use. And so they are, instead of doing it all at once, they are staggering the rollout over a long period of time in CalWIN counties. Until CalSAWS is up in CalWIN counties, the system that works with CalWIN, My Benefits CalWIN, will still be available for clients to use to be able to apply and do a few other things online. The Benefits Cal system has a lot of stuff in it, and there is a lot more coming that I hope will be helpful. People can apply, people can do their recertifications and STAR 7s now in Benefits Cal. They can upload and submit documents, and hopefully, I think it's been moved to January, crossing fingers, people will be able to apply for homeless assistance and will be able to request supportive services on Benefits Cal, hopefully. Ramona asks, how can we receive access to these systems and training to use them? That's a really good question. They have not really done much training for the public at large. They did not really do any training for CBOs because they didn't create a CBO portal. They're working on that now, and they are working on they're working on an authorized representative form, particularly for community-based organizations to use. What I think will happen is once that is operational, and I think, looking at the sky, but I think it's supposed to be ready to go in July. If folks wanted to get CBO access, each county has to grant that individually, and I don't see why you couldn't ask for that. And that would give you at least some additional access that's sort of similar to what you had before with See for Yourself. And I think YBN had that too. But that would be, I'm not sure who exactly to contact. It's a county by county thing. It doesn't exist yet. So there's still working through things like that. I can certainly, the next time I hear something about that, I can certainly ask what they're thinking about access for community colleges. I don't see any reason why community colleges couldn't ask for access as a CBO. It seems like we should be able to. Oh, for access to CalWin, they're not making any changes at all to the CalWin computer system because it's a dying system. And so really, they're not going to do any favors for anybody in CalWin. And the thing to do now is to just wait for Benefits Cal. I'll also say, if you're helping folks with CalFresh, getcalfresh.org still exists. And that is a different way to apply just for CalFresh, which has been around for a while and works pretty well. A couple other programs I want to talk about. The Housing Support Program is a program for people who are receiving CalWORKs to be able to get help with housing. Every county program is different and has their own rules for how they do the housing support program, but it can be up to, some counties pay up to a year of rent for folks, help with housing search, help with all kinds of other housing services. It can be a really helpful program for folks. The big change in the housing support program was legislation last year that it is now available to pay back rent and for somebody to remain in place, for someone to get housing support program before they had to actually move or had to be physically on the street homeless. That is no longer the case. And also now someone can get the housing support program when they get a notice to pay rent or quit, a notice to quit, or if the housing is defined as unstable. So there's a concern about inability to pay rent or eviction has been threatened or such things. So it's a nice expansion of the housing support program. The county's also got a fair amount more money with it. And so hopefully there'll be enough money to cover everybody, but we shall see about that. There are also a lot of changes, positive changes pending with the homeless assistance program. This is the program for people who are moving that provides security deposit and last month's rent. I'm not going to go through all of those changes right now because at this point they are not being implemented. They are on hold until the CalSAWS computer system is rolled out in all counties. So they're going to be on hold for at least another year, maybe longer than that. So instead of confusing you with all those changes, just know there's some good changes coming with the homeless assistance program that should be implemented when CalSAWS is entirely implemented. It's a bit disappointing that they decided to wait, but the legislation allows them to do so. And so that is what they have done. So I'm not sure if any of you have seen this particular problem, but there has been a real issue with people losing their benefits because of skimming or scamming. Skimming would be electronic theft of benefits from ATM machines or other point of sale devices. Scamming is people doing things to trick people to give out their passwords to get into their account. And so these rules are better than rules you might have seen before. It's because of a highly successful lawsuit that Legal Aid Foundation of Los Angeles did about some of these rules. And so there's a new all county letter implementing. There's also legislation pending now about them. But the general rule is if someone has lost their benefits to skimming or scamming, they have to file a report within 10 days of the electronic theft. And so people cannot wait. If someone comes to you and says, I think my benefits were electronically stolen from me, they're just gone, they have to file a report immediately, because if they wait longer than 10 days, they've lost the benefits forever. It's harsh, but that's what the rule is. Once the report is made, the recipient has to complete a special report form within 90 days of the electronic theft. There's no longer a requirement for a police report, which is kind of nice. Probably a good idea to have one anyway, but it's nice that they're not requiring that anymore. And the county will only replace electronically stolen benefits no more than twice in a 6-month period. The process is actually a little funny. When you file the report, there's an initial determination made by the EBT vendor, FIS. And FIS makes a determination about whether they think the benefits were electronically stolen or not. If they say yes, then no problem, the benefits are released. If they say no, then the county makes a decision about whether, based on the evidence, about whether they think the benefits were stolen or not. And yes, there is. The time frame for replacement is within, they have to make a decision within 10 days about whether they believe the benefits were in fact stolen or scammed. The report is filed with the county and they give it to FIS. It's a little clunky, that's for sure. But that report gets forwarded to FIS and you go from there. And you can see I cited the 2 all county letters that address this process. Effective date is now. This has actually been the process since 2018, but it's updated now because of the result of the Legal Aid Foundation of Los Angeles lawsuit. And I see a question. I'm going back to, I see Esmeralda's question. And I see it was a denial that they wouldn't give the $500. Even though the class schedule shows 12 units, students should request a hearing. Yes, absolutely. That is the remedy when that supportive services payment is improperly denied. Couple other important things. Couple changes to verification requirements. One is about pregnancy verification. And now someone can submit a sworn statement to verify pregnancy. There does have to be medical verification within 30 days, and that can be extended for good cause. But now people can apply and start getting their benefits based on a sworn statement to verify pregnancy. These are some changes that were put into place because of COVID initially, and now because of legislation, they are remaining in place. And so now an applicant can sign an attestation for an application and can do an application by oral attestation if they cannot provide a physical signature. Or if the county is unable to do an electronic or telephonic signature. There does have to be a physical signature submitted within 30 working days of the oral attestation for everything except homeless assistance, and those forms should be mailed to the applicant. There is legislation pending about requiring electronic signature, requiring all counties to have electronic signatures. And counties that do can just use those, but counties that do not, at least now, an oral attestation is possible. I'm going to go back through the chat in a moment, but let me finish. Let me do one more slide and then one other thing that I should have had a slide on that I want to say something about. a small change to the requirement to provide photo identification. And now applicants can present that virtually or in a video conference. And so people can scan and email their photo identification now, and the counties have to accept that. Again, something that started with COVID, but legislation has now codified that is required, that counties must accept that. I want to say one more thing that I didn't do a slide on because it's very new and we're just learning about it. But you might hear about this from some folks very soon. So on the back of EBT cards that have been issued in the last 4 or 5 years, there is a CVV, that 3-digit number that's on the back of your credit cards. It's a security feature that is now on the new electronic benefits cards. It had not been turned on until now. The Department of Social Services is very concerned about skimming and scamming. And so in a way to try and increase security for benefits for EBT cards, they are activating the CVV on the cards. The problem is that anybody who has a card that's more than 4 or 5 years old, I'm not sure exactly when the cutoff is, those cards are no good anymore as soon as the CVV is turned on. And so the Department of Social Services, through the vendor, sent out new cards to anybody in that situation. The estimate was they sent out, give or take, about 900,000 cards. And from the numbers that I have, only about 30 or 40% have actually been activated. There were a pretty large number, about 30,000, that were returned as undeliverable to FIS, and everybody else just hasn't activated theirs yet, which is sort of understandable because it came in a completely nondescript envelope with no information at all in it. The reason they did it that way is because they were afraid if they publicized this in any way that the scammers would steal the cards from mailboxes. And so they did their best to make sure there was no information about it to anybody, which made it more difficult to steal them, but also meant that people who received them had no idea why they were getting them or what in the world was going on. For the cards that haven't been activated, DSS has sent out, text messages or trying to call people. I'm not sure how successful that has been. But it also turns out that because of a data match mistake, they sent out new cards to people who have been removed from the household already. And so there are about 30,000 cards that went to the wrong people who should never have had access to the account because they were removed from the account. This is a statewide problem, it turns out. The DSS did send out instructions to counties about that, but did not publicize it in any way. If you do need those instructions, I have them and I'm happy to give them to you. If you've got folks who think they had their benefits stolen that way and the county is not honoring it, there's at least something from DSS to show them to say, wait a minute, no, the client is not making this up at all. I can figure out a way to get that out to people. I'm worried about this because when the CVV is turned on, all the old cards are going to stop working overnight. It's going to be sometime in May. We don't know when. I asked them to please not do it in the first week of the month because people need to pay their rent. But who knows? If somebody comes to you with the problem of magically my EBT card doesn't work, that's probably why, and then we'll need to call FIS right away. It's the 800 number on the back of the EBT card to get their replacement card right away. And hopefully they'll be able to get their card fast enough that there's no harm to them from it. let me pause there. There's a whole lot of stuff in the chat, so I need to go back and see what is here. Because they were coming really quickly, so hold on. Yeah, I see the question from Esmeralda. I'm seeing the more specific question now, that they were denying the supportive services because they were an exempt volunteer. But now they're actually required to be enrolled. So of course, since they were required to be enrolled, they're entitled to the supportive services payment. But exempt volunteers are also entitled to supportive services. And so the fact that somebody is an exempt volunteer, as long as their volunteer plan is approved, they are absolutely entitled to those supportive services. That is a separate problem, and that is definitely worth requesting a hearing about. And I see a question from Deborah. Give me a moment. Campus assistance free. Yes, Deborah, that student, they're going to lose their DV homeless assistance. Well, let's see, when you say DV transitional housing, if they're in a transitional housing placement and they haven't gotten anything from the county, then they can apply for homeless assistance. And then once they're in place, they can apply for the housing support program. And that's how they can get assistance. And there is also a special once in a lifetime homeless assistance program for people fleeing domestic violence. That's 32 days of temporary homeless assistance instead of 16. Although they might only get the 16, there's a fix to that that's held up in the programming delay. But they can at least get 16 and then get the regular homeless assistance for another 16. And then they can get their permanent homeless assistance to get into a place, and then they can get housing support program, hopefully, and that can help them with their rent for a substantial period of time. Yeah, right. They just need to go they need to go into the office and ask for it. They should do it in writing. If nobody will talk to them, give a letter, keep a copy of it. And if nobody responds, request a hearing. And hopefully a hearings representative can fix it. And I see another question here. Our county pays for only required supplies. That being said, does this $500 amount apply to recommended and required supplies or only required supplies? The $500 is a flat rate. And so the county can't even ask what it's being used for, is the answer. So it does not matter. Nobody needs to present proof that a textbook is required for a class anymore, or that certain supplies are required for a class. If someone is enrolled full-time, they get the $500, end of discussion. Yeah. And again, I see if the participant wants to purchase recommended supplies, they can purchase whatever they want. If a student started their semester in January, purchased their books, then became, unfortunately, they're correct. They don't have to pay it retroactively. Marta, unfortunately, I think the county is correct about that. They do not need to pay supportive services retroactively. Give me one moment. I'm looking at some other chats here. Nadia asks, how long does it take to have an EBT card replaced? Well, it's supposed to happen pretty quickly, and there's still a lot of confusion about whether all of them have to go through FIS, or whether the county can use their card stock that's on site. Initially, the instructions were that everything had to go through FIS, but I think the state is backing down on that now, and is allowed, if the county has card stock on staff, there's no on site, there's no reason why they couldn't replace it that way. If not, I'm guessing it's at least 3 to 5 days, but unfortunately FIS is located in Florida. So who knows how long the mail will take to get there. But hopefully they're supposed to send it out pretty quickly. The specific form to file for scamming, it's the same form as for skimming. And I actually had the number in there. Let me look at it. It is the EBT 2259. Is the form and it's on the Department of Social Services website. Vicki, you think that they are required to pay the retroactive payment? Let me look at it. Let's look at it. If there is, if I'm wrong about that, that's great, and there should be a hearing requested right away. I need to look at that. Let me write myself a note. And let's see, I see, can CalWORKs or TANF funds be used to cover CalWORKs students' enrollment fee balance? Well, I mean, the supportive services payment can be used for anything that the client wants to use it for. And if the client wants to, use the money for an enrollment fee, they can do that. That said, supportive services does not cover tuition or fees in the nature of tuition. And so you can't separately ask for coverage of tuition or fees in the nature of tuition, and you can't use a balance like that to say that the supportive services need is more than the standard supportive services amount, the flat amount. So I hope that answers your question. So things like, tuition, or things like the health center fee or the student center fee or something, unfortunately, dare I say, I filed a lawsuit, went to the Court of Appeals about it and lost. So unfortunately, those things are not covered as supportive services. Yeah, let me check about that, about retroactivity. Where is the CVV number located on the EBT card? On the new one, it's on the back of the card, I think. It's just like your credit card, because on your credit card, you've got the credit card number, and then on the back, you've got that little 3-digit number. It's that. And it's in an equivalent place. But actually, let me take that back. Let me correct that now that I'm thinking twice about it. They didn't put the number on the card. The card is embedded on the CVV number is embedded in the chip, but they did not put the card number on the card. They did not put the CVV number on the card. Let me pause there. Any other questions? I certainly have more stuff to talk about, but I wanted to make sure that I left time for questions. If we don't have any other questions, what I'll do, I didn't do slides about these because I wanted to make sure we had time for questions. But let me mention a couple of CalFresh things that are mostly changes that are coming relatively soon. first thing that is most important for all of you is the expansion of this CalFresh student exemptions because of COVID. There were two expansions, two additional categories of folks who are in college, who are in higher education, who are exempt from the rule that folks in higher education are not eligible for CalFresh. It is folks with a zero financial aid contribution, and it's anybody receiving financial aid. It's an expansion from the funny rule of able to get it and have a chance at getting a work study spot. It expanded that to anybody who is eligible for work study. And it's been really good. There's been a whole bunch of college students who have been able to get CalFresh because of it. Attempts at the federal level to make those permanent have not been successful. And so we're not sure yet when that expansion is going to end, but it will end when the COVID state of emergency ends. So that'll be a little bit unfortunate. There's going to be a fair number of college students who will lose their CalFresh. What'll be good, what'll need to happen when the two new exemptions happen is hopefully the counties will evaluate for any other exemptions that might apply. If they don't and people come to you, if they don't and people come to you, then I think the advice is to look at if any other of the CalFresh exemptions apply. At the very least, have people talk to their worker at the county welfare department about whether any other exemptions apply, or to talk to a local legal aid office about whether any other exemptions might apply. Another important CalFresh thing is the emergency assessment, is the emergency allotment. And so students, everybody is getting the maximum amount of CalFresh now because of COVID. That is being extended on a month-by-month basis at this point. We don't know when that is going to end. The state is giving a request to the federal government every month to say, let us do the emergency allotment for one more month. And so far, the federal government has granted it, but who knows how long that's going to last. The nice thing about this, and I'm seeing some issues with this, is if there are overissuance allegations during the time of COVID, if the client was eligible for any amount of CalFresh, if they were eligible for $1 of CalFresh, then there's no overpayment because the emergency allotment would have made up any difference that they have. And I've seen this, I've seen counties making this mistake a fair amount. And it's very important if there are CalFresh overissuances during COVID, that counties are doing that right. I am seeing a couple of things in the chat. And question, what if the student has a job, can they still get CalFresh? Yes. The working for 20 hours a week exemption to the CalFresh student rule has not changed and will continue after COVID. But I'm sorry, I'm trying to figure. Vicki does have a good point for folks who are living with their parents and going to college. They are considered part of their parents' household. They cannot be a separate household until they turn age 22. And so their parents' income would count. The whole household would have to apply for SNAP. They're not eligible for CalFresh on their own. Question of what is the income limits? The easiest way to look at that is there's a chart on the Coalition of California Welfare Rights website that gives the income limits for CalWORKs and CalFresh and various other programs. Another place to look is the Legal Services of Northern California CalWORKs guide. And in the CalWORKs guide, there is a calculator that you can look at. And that would give a really thumbnail sketch about whether somebody might be eligible based on their income. There's a question, is the IRT different from county to county? No, it isn't. It is the IRT is the same statewide. I agree, Vicki, that the age 22 rule is a dumb rule, but unfortunately we are stuck with it. So once a student turns age 22, or anybody living with their parents turns age 22, then we evaluate whether they can be a separate household, which is done by determining whether the family members purchase and prepare their meals together or separately. If they purchase and prepare their meals together, they have to be the same household. If they do not, they can be a separate household, which means somebody who is age 22 who purchases and prepares their meals separately from their parents can get CalFresh for themselves only and not be stuck with their parents' income. We've got about 2 minutes left. Any other quick questions? And let me, if you've got any questions for me, let me put my email in the chat. I'm happy to talk to you. Please feel free to contact me, except I need to do it to everybody. Let me try that again. Please feel free to contact me. I'm happy to talk to you about any questions that come up. And if there are no other questions, I will stop the recording. Oh, wait a minute. I see, hold on. I see a question, 120 days of motel vouchers. Vicki, I'm not sure what you're asking. For homeless assistance, the hotel vouchers are only 16 days. There have been various COVID programs and other housing programs that have given motel vouchers for various things. And quite possibly the housing support program can give housing support, can pay rent vouchers, however the county decides to do it for 120 days or even longer than that. But other than that, I'm not sure what you're asking. One more quick question. I see a question about restaurant meals program. Yes, homeless folks are eligible for the restaurant meals program. That is a CalFresh thing that allows people to use their CalFresh in restaurants that participate in the program. It's a great program. And my title is Regional Counsel for Legal Services of Northern California. I'm happy to stay on, but I'm going to stop sharing and stop the recording, but I'm happy to stay on if people have questions. Stopping the recording now.